Hello, ladies and gentlemen. Emeku Buonye. Today is 18th of January 2022. It's going to be my presentation this morning is going to be on the case of Nnamdi Kanu, which comes up today at the Federal High Court here in Abuja. And many of you, my followers, are trying to know what I would think, or have been sending me messages asking for my opinion or my predictions concerning today's event. I think it is important to talk about today's case because there are a number of developments that are worthy of very close attention and study. And these are, first and foremost, this is the first time Nnamdi Kanu is coming to court after President Buhari made it clear that the government of Nigeria is not considering any intervention in the direction of releasing Nnamdi at the behest or request of the Ohanese and the Igbo delegation. The president made it clear, because before now people were thinking that Nnamdi was going to come out, not necessarily because of the judicial proceedings, but because of some extraordinary intervention from the executive arm of government, the presidency. So the hope was there that Nnamdi would come out, that something will move Nigerian government to release him. So that has been put to rest. The president made a broadcast and indicated that the Nigerian government would not intervene. In other words, that they would want Nnamdi to go through trial. Even though the argument of the presidency for that, as I had explained in the previous broadcast, the government's argument is not really correct, because the president says, I am not intervening because there's separation of power in Nigeria. I'm executive and I don't want to interfere with the judicial proceedings. That is wrong. I have said this so many times. You know why? Every criminal case in Nigeria is prosecuted by the executive arm of government. The DSS is executive arm of government. The police is executive arm of government. The Attorney General of Nigeria, who is the godfather of all prosecutions, is part of the executive arm of government. And all these people have power to discontinue a criminal case they filed. Every prosecutor in Nigeria has power to apply to the same court handling a case to say, my lord, the prosecution does not intend to continue with the prosecution. If that is done, the charges will be withdrawn. So there is nothing extraordinary in Nigerian president, that's the executive arm of government, intervening to get Nnamdi released. There's nothing extraordinary about it. All the president needed to do was a meeting with the Attorney General and say, in the interest of the country, in the interest of whatever interest he wants to consider, I want this prosecution discontinued. And the Attorney General, who has that overarching power, could enter and only prosecute. So it's not a case of the executive interfering with the judiciary. In fact, the executive will be doing exactly its executive function if it discontinues through the Attorney General of Nigeria a criminal prosecution, however initiated and by whomever it was initiated. That is the position of the Constitution. So when the President of Nigeria cited separation of power as his reason for not granting the request of Ohanese regarding Nnamdi Kanu, we knew that is not correct. But I understand, for a different reason, that the President of Nigeria would not grant release to Nnamdi, not at the request of Ohanese, not in the language and terms of Ohanese's demands, because Ohanese was talking of unconditional release, and I knew that unconditional release is just dumb. Unconditional release meant that Nnamdi could be released and told, go home, continue your life as you like, indeed continue your quest for Biafra. If you like, that would be unconditional release, because if you tell him, go home, but don't pursue Biafra, don't continue with IPAB, then that means you are imposing a condition on his release. So the word unconditional release, that term, is so provocative and annoying because I don't think Ohanese understood what it meant. Anyway, that had been put to rest. the president said no. Trial should go on, and the Nnamdi's fate should be decided in the court of law. The implication of that position is that all attention is refocused on the court. That gives today's proceeding the significance it deserves. And I will also say this because I have just said the president was wrong, but let me say one area where the president could have been right. You see, whether the president grants amnesty or pardon to Nnamdi, if you make it a political debate, if you make it a matter of open discussion, the way Ohanaeze did it, it had an effect on the proceedings because the judge begins to see the case as something that may be terminated suddenly. It may affect the judge's concentration and focus on the case. Also, the prosecution, the lawyers in the prosecuting team might say, well, there's no need to press on, there's no need to keep preparing because there is a discussion going on in the background which may likely interrupt the proceedings. So, what was interference with the judicial proceedings is the discussion. It was the discussion over the release of Nnamdi that interferes with the thoughts and preparation of the legal team, prosecution, defense, and the judge. So, that discussion was the interference. But the actual decision, the question of whether or not the president can grant, can discontinue a case that is pending, that is not an interference. It doesn't violate the doctrine of separation of power. What violates it is the manner in which the Ohanaeze approached it. So Ohanaeze did not understand. The president got it. So the president was basically saying to Ohanaeze, your move, the manner in which you pursue your move is an interference with the doctrine of separation of power. The president is right there. The manner in which Ohanaeze left a pending case, engineered these processes of canvassing for the release of Nnamdi, that was in itself an interference. It is not whether or not the president had power to do so. The president does have power to do so. But politicking and campaigning over it was an interference in the judicial proceedings. But anyway, it's now behind us. We are in court. The case is going forward. And there is something that happened, which is worthy of note. Yesterday, Ejiofor Nnamdi's lawyer made his typical angry outburst, indicating that the Nigerian authorities, that's the Nigerian government, prosecuting them, had amended the charges all over. They have amended the charges. Of course, Ejiofor, in his manner, was angry about it. He called it nonsensical, worthless amendment. But that's wrong. That's not how to go about these things. These outbursts don't solve anything. If the amendment were worthless, you thank God that the prosecution is coming up with a worthless charges. Worthless charges means you should be able to defeat those charges or defend against them. So how can a defense counsel be so worried that the charges against his client are worthless? No. I'll be happy to see that the charges against my client are weak. But of course, there is a concern that with each new amendment of those charges, there will be a rearrangement. A rearrangement meaning the charges will be read to Nnamdi, and Nnamdi will plead guilty or not guilty, and the issue of pretrial detention, that is bail, will start all over. Yes, it is true. It is true that if those charges were amended, if new charges are coming up today, then all the previous bail applications will be impacted. Oh yes. Now, if you remember, very early in this case, I said that the focus of the defense team is to find out how many charges, what charges are actually coming out from the prosecution. Focus on that. Otherwise, the prosecution can keep playing this game of coming up with amended charges from time to time and resetting the entire process from day one. Because each time an amended charges comes, they press the reset button and it goes back to day one in terms of the procedural timeline to get bail, to get trial underway. So that is a trick. The prosecution is playing it. The defense has not adverted to it, despite my so many warnings, because I have warned so many times that the federal government of Nigeria can keep on propounding charges upon charges on Nnamdi and drag this process indefinitely. I said so. I am surprised that none of the defense counsel considered this option, and the Ohanese people sending up a legal team, lawyers to meet the Attorney General. The focus should have been to get Nigerian government to be very clear. What charges do you have against Nnamdi? Can you please come forward with those charges at once, so we know what we're defending against, so we know what we're battling? Otherwise, the Nigerian government continues to charge Nnamdi in piecemeal. They come on with charges, and as the argument for bail is going on, they amend those charges and restart the argument afresh. So it is now obvious, not only that the court will not grant bail on the applications pending, but also that a new application will be needed to address these new charges. Because when you seek for bail, you seek for bail based on the charges presented. It is part of the argument. So if you don't know the charges, it's difficult to argue for bail in advance of charges. So essentially, if new charges are coming in today, certainly Nnamdi cannot come out. So all those applications put out there, application for bail, that's not going to happen. Application to transfer him to Kuje prison, that's not going to happen. Application to get the court to declare that it has no jurisdiction because of rendition is not going to happen. So today's trial is nothing but arraignment. Nnamdi will be rearraigned today on fresh charges, new bail applications. Maybe they'll have to modify bail applications. Okay, the court may decide on the issue of jurisdiction because the amendment of charges will not affect the application of jurisdiction. So the court is going to decide on jurisdiction. The court may also decide on the issue of where to detain Nnamdi, but on the question of bail, the court may say, hey, well, you can reapply for bail, or even if the court decides on the previous bail application, the new charges, the amended charges, will forestall any possibility of a final determination on the bail question. So those of you who are expecting that Nnamdi will be released based on the intervention of Ohanese, you now know it's not going to happen. And those of you believing that he might be released on the proceedings in court today or tomorrow or this week or soon, you know it's not going to happen. Just take that what I have told you, that one from day one is not going to happen. It's not going to happen. Okay? And why? Because I understand the law. I know how it works. You have to put the sentiment and emotions aside and focus on the law. Then you calculate the mindset and the attitude of the parties. You put them all together in this calabash and shake it. Then you come up with what is the likely outcome of any case you are in. You have to be patient, you have to be careful, you have to be methodical, and you have to understand the dynamics. So looking at the case, looking at the totality of it, Nnamdi is not going to come out. Put yourself in the position of the opponent. That has always been my strategy as a lawyer all my life. I decide to know what the other side is thinking. So I ask myself, if I were in their position, what would be in my best interest? How will I pursue it? What will I do if I were in their position? Many of the Nnamdi lawyers, Nnamdi Kanu's lawyers, have never tried to put themselves in the position of the DSS, put themselves in the position of the presidency, put themselves in the position of the Attorney General. So you got to understand this. Imagine yourself a lawyer for the other side. When you imagine yourself a lawyer for the other side, then you begin to see things with the eyes of the other side. Then you return to who you are, an opponent. Then you are better able to oppose them because you know what they're thinking. But what has been happening in the Nnamdi's case is very funny. A Geoffrey thinks only as a Geoffrey. A Geoffrey sees the world as a Geoffrey. A Geoffrey sees the world just from his prison. It is impossible, it has been impossible for him to anticipate the prosecution. He was surprised that there was an amended charge. I can actually tell him now there will be more. They will keep amending these charges because you haven't done what is necessary to forestall these amendments. And these amendments are a tactical weapon in the hands of Nigerian prosecutors. They are going to stretch it to the extreme. They're going to use it to squeeze the last drop of juice out of Nnamdi. That is the game. That is the strategy. If you understood it, you focus on it. If Ohaneze understood it, they focus on it when they send delegation to meet the Attorney General. Also, we heard, I don't know how serious it is now, we heard that Nnamdi's team were trying to get a better lawyer to lead the defense, a more experienced, more tactically sound lawyer to lead the defense. That may happen now. This is the time to get that to happen. Bring in a sound, mature, calculated lawyer who could put a very coherent defense strategy for Nnamdi, to play down on the media activity, to play down on the drama and entertainment value of a Geoffrey strategy, and focus on law, focus on defense, focus on winning, focus on denting the prosecution's strategy. That's what you can expect going forward. All right. Now I will also talk about the case coming up, the judgment we're expecting to occur on the 19th at a court in Abia State. You must know, whether you like it or not, whether you like me telling you this, Nnamdi's defense team is split. They're not the same, they're not thinking the same way. A lawyer, Jimako, is a sound lawyer, better lawyer, no doubt. More mature, more restrained, more professionally intact. I don't know, but I don't think he's swimming along with the Geoffrey's dramatics. So, in any case, a lawyer has a parallel approach. He understood the fundamentals of this case. He knew that the only way Nnamdi could make progress is if he could successfully focus on rendition and attack his rendition from Kenya. So, Aloy Ejimako went to court, filed an application to enforce Nnamdi Kanu's fundamental right on the basis that the manner he was taken out of Kenya and brought to Nigeria was in violation of all known law. Aloy is correct. Almost everybody agrees that regardless of the pending bench warrant, regardless of the situation, Nigeria is supposed to go through extradition proceedings to move Nnamdi from Kenya to Nigeria. So a court, properly, when you plead this case, if you present this argument very well, a court is going to find, and I think it's going to happen on Thursday because our lawyer has done a very sound job on that to the best of my opinion. The court is going to find that the rendition was unlawful, the rendition was violation of Nnamdi's fundamental rights, and the court is going to award damages. Of course, I know our lawyer is expecting more. Our lawyer is expecting that the court is going to order his release. No, the court is not going to order his release. The Abia court will not order the release of Nnamdi. You know why? Because Nnamdi's detention is pursuant to an order of a court. And that's a court of coordinate jurisdiction. So a high court in Abia State cannot overrule a high court in Abuja. It will require an appeal court to do so. But of course, if a lawyer wins the argument on the right of Nnamdi in Abia State, it opens an avenue and strengthens an appeal against the order in Abuja for him to be detained. So we don't know what's going to happen, but we just tell you to look out. Do not be too, don't raise your hopes. if your hope is that Nnamdi is going to be released, dash that hope. It's not going to happen. Okay? Not now, not soon. Okay? But if you want to see the law unfold and understand this case better, today's proceedings, this week's proceedings, will give you a fairer idea of what it's all about. Good luck and enjoy your day.